the state of Florida is now in session. The Honorable James Edwards, Chief Judge, presiding. All persons have business before this court drawn near. If attention will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning, everybody, and welcome to a remote and Halloween version, it sounds like, of oral arguments for the 5th District Court of Appeal. I'm Chief Judge Jim Edwards from Seminole County. To my right is Judge Rand Wallace, also from Seminole County. And to my left is Judge Boatwright from Putnam County. We have 3 cases on our docket this morning. We'll take them. And if the attorneys have time, since we have some students from Stetson who are pre-law, maybe take a couple of minutes. If you have time, if you need to leave, we understand that. And we'll maybe entertain a couple of questions, or at least let you explain to the students why you decided to come over here. And if you need to leave, just let us know. That's fine. If you have a noise-making device like a phone, please turn it on silent or vibrate, because it will certainly go off at the absolute worst time. With that, we will go ahead and get started. Each side will have 20 minutes. We typically give the appellant 5 minutes for rebuttal. If you want something different, just let us know, and Marcia will set that up. The time that shows on the clock is your total time. So each side gets 20 minutes. So whatever's left on your clock, that's your total time. You don't get another 5 minutes before rebuttal after your clock runs out. Green means you're still in your good time. Yellow means you're going into rebuttal. And red means it's time to wrap it up and sit down quickly. Okay, with that, our first case is case 23-2480, Kenneth Kolke versus Homeowners Choice Property and Casualty Insurance Company. Counsel, if you need to move that clipboard, feel free. It's not much fun.
Chief Judge, Your Honors, may it please the Court, Jeremy Bailey on behalf of Mr. Kolke. Chief Judge, I would like to reserve the 5 minutes for rebuttal. This case, I think, can best be described as the tension between 2 competing principles. On one hand, you have the concept that the rules of civil procedure have to be followed, have to be enforced. But on the other hand, you have this public policy that this Court has discussed that cases should be decided on the merits and not on the technicalities, technical defaults or technical omissions. And I think that tension can be resolved in this case by asking 2 questions. And the first is, did the trial court apply the correct legal standard when evaluating the request for relief under 1.37? And the second, and I think the answer to that is no. And the second question is that if the correct legal standard had been applied, is this the type of case where the defense should run on a technicality, or whether the rules should be liberally construed in order to have the case resolved on the merits? And I think this is the case that should resolve on the merits. On the first issue, Rule 1.370B is pretty clear. It says that the party who obtained the admission is the party that must show that there is prejudice for the court if the court were to set aside the technical admission. And when the court went through this analysis, the court repeatedly placed the burden on Mr. Kolke to prove that HCI would not be prejudiced.
Counsel, is there any significance to the added dynamic in this case that when this was raised, the jury had already been selected and sworn?
I don't think so, Your Honor, because the one case that the trial court relied on for that principle was the West v. West case. And in that case, the actual holding of the court was only that there had to be a motion under Rule 1.370. I think that's actually the last sentence of the second full paragraph. It says, we hold that in order for the trial court to grant relief, there must be an actual motion filed. Because in West,
but in order to say that you tried the case on the merits, the jury was sworn, counsel for HCI had already formulated a plan to try the case that involved the, I believe, giving intentional decision not to take certain depositions and conduct certain discovery because of your counsel's failure to respond to the request for admissions. So merits, trying it on the merits, what would that relief look like in this instance? Would that look like declaring a mistrial and retrying the case, or going forward and just have the court deem the admissions to be admitted in error? And so it's a little more convoluted than just a clear rule the admissions as not admitted and moving forward. You would agree?
Partially, Your Honor, and I think that's a factor that the trial court could have taken, should have taken into consideration. But and I think two things. One is, I think the predicate question would have been, following the plain text of the rule, right? Did the trial court correctly determine whether or not that it should have been set aside? And then the secondary question would have been, how does that practically work, right? Do we, continue the trial? The jury's sworn, or you can continue the trial for a number of days and let, whatever deposition can be done occur. But I think that goes to the Melody case, right? So the Melody case, this court talked about, it's not prejudice to have to try the case on the merits, and the claim of prejudice rings hollow when the thing that's being claimed doesn't really match up with the facts of the case. So we had the argument from counsel that said, I would have done, more depositions, I think was just kind of the general phrase, more depositions. But the requests for admissions in this case were served back in October of 2021. So for 2 years, day 31 comes, they're deemed admitted, and if the position really was, we're framing the case based on these admissions, then for 2 years, the HCI took their positions. They served written discovery, multiple sets of interrogatories. There's continuances for trial because they needed to be prepared. There were motions to compel discovery, right? And there's all these things, all these machinations that were done.
Why not just respond to the admissions?
It was a failure. There's no doubt about that. I don't think that can be argued at all. The affidavit from the paralegal is clear. She filed she believes she filed the responses, but they weren't served. And that actually does, on that point, the record as a whole does show that this was that type of foible, right? So if you look at the interrogatories that were served and the request for admissions that were inadvertently not served, interrogatory number 6 says, if you deny any of the requests for admissions, please take the basis for your denial. And they responded in the interrogatory, right, responding to the denials, but then apparently inadvertently didn't actually produce the response request for admissions. So your point is well taken, Your Honor, that this was a tricky situation, but the trial court never got to remedies, never got to, potential continuances, mistrial. The only remedy that the trial court offered was, does Mr. Polkey want to pay all of the attorney's fees and costs incurred by the defendant up to that point? But that didn't really seem to match curing prejudice, right? It wasn't a matter of, do you want to, continue the trial? Do you want to, maybe declare a mistrial and have him bear the cost of that expense? I don't know what that would look like, but we never even got to potential remedies because the trial court started off by saying, Mr. Polkey, it's your burden, when the rule provided that it was HCI's burden to show that it would have been prejudice. And
did the trial counsel raise the fact or the point that he believed the judge was using the wrong standard down at the trial court level?
I don't think there's any magic words where he objected and said, Judge, you're using the wrong standard. But it was clear from his argument, and that I think I have the record sites. I apologize, I don't have the record sites in front of me. That in 2 specific instances, trial counsel specifically argued that the trial court has to grant relief unless there's prejudice shown by the other party, right? And that was the fundamental premise. And
did the judge find defense would be prejudiced if the relief was granted, based on their strategy to, rely so heavily on the unanswered responses? responses?
Yes, Your Honor. So that really goes back to the Melody case, right? And whether or not having to try the case on the merits is actual prejudice. Because I mean, what the court says is that in paragraph L of the order, quote, this court further finds that the plaintiff has not met his burdens, and that if the court were to grant relief for the deemed admissions, there was no showing by plaintiff establishing that the defendant would not be prejudiced by setting aside those deemed admissions which were relied upon by defendant. So the only prejudice, so we have the two issues there, right? We have the improper burden shifting, but the only prejudice that the trial court articulates is that the deemed admissions were relied upon by the defendant. And that's what this court said in Melody Tours was, that's not enough. That's not enough prejudice. Because if that was the case, every defendant, every party that obtained the admissions has relied upon them, right? And there would never be an opportunity to grant relief. So, under the abuse of discretion standard we set in Knacker's case, at the very outset, the trial court started down this road and applied the incorrect legal standard because HCI's trial counsel told the trial court, this is the legal standard you have to follow.
Did you raise that in your motion for rehearing?
No, Your Honor, it wasn't specifically raised in the motion for rehearing. The motion for rehearing essentially just argued that the record evidence showed that the deemed technical admissions should be set aside. And I think that's an important point too, and that kind of is my second point, is that when you're looking at a case like this, and I think this court has looked at, there's 14 written opinions from this court on Rule 1.370. The touchstone of the analysis really is, what are the technical admissions going to, and what does the record evidence in the case show about those technical admissions? And so, a couple things on that. Number one, this is not a denial. And that's important because this isn't a case where the insurance company has said, no loss, no covered loss has occurred here. This is an amount of loss dispute. So the insurance company opened coverage about $11,000. Mr. Kolke submitted evidence showing that about $60,000 of there's a amount of loss issue. And when you look at the request for admissions, the first 6 have to do with conditions preceded under the policy. And frankly, those wouldn't have directed the verdict for HCI. There are still issues of substantial compliance, additional prejudice, there's other things that have to go into that. 7, 8, and 9, and really 8 and 9 are the heart of the directed verdict. 8 being, at the time the lawsuit was filed, no payment was owed under the terms of the policy. And 9, homeowner's choice did not reach the policy. So when you're looking at what quantum of evidence does Mr. Kolke need, I keep coming back and forth volume-wise, what quantum of evidence does Mr. Kolke need to show that 8 and 9 are contradicted by the record? And actually the fact that we were at trial helps Mr. Kolke, because both sides have then submitted hundreds of pages of trial exhibits showing the record evidence in this case. This isn't a case where the parties had to scroll through depositions and transcripts and try to find things. It was all quite literally before the trial court at that time. And Mr. Kolke had mold reports, mold assessments, inspection reports, photos, estimates, invoices. He had all this quantum of evidence showing that his total damages totaled over $60,000, and HCI had paid about $11,000. So when you look at the record evidence, what he needed to show that 8 and 9, 7, 8, and 9 were contradicted, because I think that's the touchstone of the analysis. He had all the record evidence right there before the court, and had the court applied the correct legal standard, and had asked HCI, what is your actual prejudice, other than trying the case on the merits, other than relying on the deemed admissions, what was your actual prejudice? And then, I think that was the important point of Walsh, because then the trial court could have turned to remedies, right? And looked at how giving Mr. Kolke an opportunity to offer solutions to cure that prejudice. And this happens all the time, for instance, like in the finger analysis, right? Where there's a surprise witness, and the trial courts have discretion to work within the parameters to maybe continue the trial for a day and allow a deposition to occur. Or fashion a scenario where we're still enforcing the rules, and that goes back to the tension. We're still enforcing the rules, we're doing it in a way that still gives credence to this idea that we have this liberal policy of allowing cases to be resolved on the merits. And the last thing that I want to point out too is that the trial court seemed to have made a legal determination, separate apart from its error on the burden shifting, that because Mr. Colton first moved for relief at trial, that there was a categorical bar on seeking relief at that point. So, and I think that was just plain error as well. But number one, there's nothing in the rule that says if you want to seek relief, you got to do it prior to trial. That's not the rule. When the rules have wanted to say that, like for motions judged on the pleadings, they have said that, right?
Did you file a motion to set aside these motions?
Yes, on my point. The same evening as that the issue was raised in the trial court. So after the jury was sworn, counsel for HCI moves for a directed verdict. There's a colloquy, the court adjourns, and that evening the motion for relief was filed and the affidavit was filed. I think there was some suggestion by trial counsel about the court tennis motion, but the first real motion that was filed was that same evening, and then the next morning the trial court had another hearing on kind of the whole issue.
If you're able to show excusable neglect, then does prejudice matter to HCI at all? Is there any balancing, or once you show excusable neglect, that's it?
There still is the prejudice analysis. The excusable neglect was taken from the language of this court's opinions in Shelton and Melody Tours. Melody Tours specifically because in Melody Tours, the trial court said you have to show excusable neglect. And then this court said, no, that's not really the rule anymore. In 1972, we've liberalized the standard to make it easier to get relief. But the idea of excusable neglect goes to, what was the basis for the failure to respond, and then was there diligence, kind of in that package of, was there diligence in moving to set aside the technical admissions? Because like the City of Tamarack case, was relied on the trial court, but it's so factually dissimilar because in that case, the plaintiff got a motion for summary judgment that was specifically based on the failure to respond to the admissions, and then sits on his hands for 5 months, and then only after the summary judgment hearing, when apparently saw how things were going, then filed a motion that evening, and the court said that in that totality analysis, that's not it. Right? That's not moving promptly and doing your part to get relief. So I would like to reserve the remainder of my time.
That's fine.
Thank you.
May it please the court, I'm Brian Hall, appellate counsel for Homeowners Choice Property Casualty Insurance Company. No one here is disputing that the trial court stated an incorrect burden in its order denying the appellant relief from his deemed admissions. But in this case, it did not amount to reversible error. And there are 3 primary reasons why, which I will discuss in order. The first is that the appellant did not raise this error in the trial court, and it was something that the trial court easily could have corrected. The second is that the rule provides relief can only be granted if the party who obtained the admission fails to satisfy the court that withdrawal or amendment will prejudice that party and maintain a defense on the merits. And in this case, Mr. Kolke waited until after the trial had started, after the jury had been sworn, before asking for the very first time for relief from these deemed admissions. In response, Homeowners Choice argued and made an unrefuted showing that it would suffer prejudice if the admissions were withdrawn at that late stage in the case. The trial court's remarks and its ruling showed that Homeowners Choice had not failed to satisfy the trial court that it would be prejudiced by the late withdrawal of the amendments. The third point we will discuss is that the requirement that the opposing party would not be prejudiced is not the only requirement of the rule. The rule also requires that presentation of the merits of the action will be subserved by withdrawal of the admissions, which courts have framed as we discussed as a showing that the evidence in the there's evidence in the record that contradicts the admissions. And in the case below, the appellant did not point the trial court to specific evidence in the record or explain how that evidence contradicted each of the admissions. And the appellant didn't do that in his initial brief either.
Did the insurance company point out what specific depositions or discovery it would have engaged in, but for the admissions having been not responded to?
Yes, what the insurance company did, the insurance company took only 2 depositions in this case, the deposition of the plaintiff and the deposition of the appellant adjuster. And in this argument with the trial court, the insurance company specifically pointed out that it would have deposed everybody else that could be a potential witness in the case, the contractor, various other persons that had been listed as witnesses in the case. But those depositions, but the insurance company decided to forego those depositions based on the deemed admissions.
This was an intentional strategy by the defense. Once they saw the time had run on responding to the request for admissions, because nobody expected the homeowner to say, no, you didn't breach the policy, which is what one of the requests for admissions were. Things like that. Those weren't really trying to narrow issues, because if they didn't think the policy had been breached, they would have sued in the first place, correct? I mean, one would think.
I think that's a fair point, but that's not the only admission. There were several other admissions in the case, and each of those was designed to narrow the case in some capacity. And as a result of having received those deemed admissions, the insurance company didn't take additional discovery, didn't take additional depositions or ask questions in those depositions that otherwise would have been asked had those deemed admissions not been present.
And although the defense moved to compel answers to interrogatories and moved to compel the request for production, they filed nothing and didn't mention anything about the fact that the request for admissions had not been responded to until after the jury was sworn.
That is correct. And the reason for that is the rule doesn't require it. The rule doesn't require one to move to compel a deemed admission. Under the rule, it's self-executing. Once a party does not respond, it's deemed admitted until they file a motion and until the trial court allows that admission to be withdrawn. So backing up and turning to the first point, we don't dispute that the appellant referenced the correct standard and the correct burden when he made his motion. But there's a difference here between citing the standard and raising an argument or an objection that something amounts to an error. And the reason I say that is here the trial court stated the incorrect allocation of the burden several times, including in his exchanges with the appellant's counsel. And not once did the appellant object or point out that there was an error. The trial court did the same thing when he orally ruled his oral pronouncement ruling from the bench, and again the appellant did not object. The appellant moved after the trial court entered its written order and again stated the incorrect burden. The appellant moved for rehearing and even filed another amended motion for rehearing, again never raising the issue of whether the burden had been properly allocated. And one of the reasons that error has to be preserved in the trial court is so the trial court can address and correct the issue when the ruling is fresh in its mind. But the appellant never gave the trial court that opportunity, and that's something that becomes significant to our second point, which is homeowner's choice's unrefuted showing of prejudice.
So there was discovery done in this case, correct?
I'm sorry?
There was discovery done.
Yes, there was discovery.
I think what was argued by the appellant, that the record evidence contradict any of those admissions?
The problem there is that the appellant in the trial court did not point to any specific evidence and explain how that contradicted the admissions. He said there's a complaint.
So it's up to the question, is there record evidence to contradict those admissions? Not that he pointed out, is there?
Right. I think now what he's pointed to are various trial exhibits that could perhaps raise that contradiction. That was never presented, never argued in the trial court.
You're saying that issue's not preserved? Is that what
Yes,
you're
I
saying?
am. Yes. And was never argued in the initial brief either. We're hearing about it now for the first time in the reply brief and the oral argument. But as was argued in the trial court, homeowner's choice tailored its case around these deemed admissions, and it shaped the way that they took discovery, including the depositions that were not taken. And in addition to depositions that were not taken, questions that were not asked, discovery that was not served, homeowner's choice did did not object when the appellant produced documents and listed a slew of new exhibits right before trial. And the trial court had even set aside the morning to address that issue. And that issue could have resulted in sanctions to Mr. Kolke for failing to comply with the trial court's earlier orders. But Homeowners Choice, as a strategy, decided not to pursue that because it was relying on these deemed admissions. And that's a point that the trial court recognized in its order. During the hearing, the trial court specifically found and repeatedly recognized that Homeowners Choice had relied on these deemed admissions. So this was not a case where no one put on any showing or argument of prejudice, and it was decided only based on the burden. In this case, Homeowners Choice had made a substantial, unrefuted showing of prejudice, and the trial court recognized that in making its ruling. And I would add that it was not just a showing, but it was circumstances that are apparent from the record. This was in the middle of trial. This was no longer a pre-trial situation. 20 months had passed from the time that the request were deemed admitted and started trial. The appellant had not asked for relief at any point during that time. And Homeowners Choice, as we pointed out, gave notice that it intended to use the deemed admissions at trial by listing those requests without the corresponding response on its exhibit list 6 weeks before trial. And still there was no motion.
How many exhibits were on that list?
I don't know the exact number, but it was a large number of exhibits, yes.
Sounds like that was flagged and blinking lights next to it.
No,
It was
I would
one
say
of many.
it was not, but it was one of many exhibits that was on the exhibit list. But even having received that, even having gone through that exhibit list, the appellant did not ask for relief, waited until after trial had started and after the jury had been sworn to ask for relief for the first time. And in doing so, he did not refute our claim or our showing of prejudice, and did not offer or argue anything that the trial court could do that would alleviate the prejudice.
In terms of the prejudice, if the trial judge had granted relief of some kind, certainly the insurance company, say the judge granted total relief in favor of the homeowner, the insurance company then would want to go back and take depositions of the contractor and other witnesses, correct?
Yes, that's
And that would incur an expense. But beyond that, what would the prejudice have been? I mean, were witnesses unavailable? Y'all never got to that point of discussion.
It never got to that point. There's nothing in the record that really gives that indication one way or another. But the point that we're making is that Mr. Kolke didn't offer or didn't ask for a continuance here that would have alleviated that prejudice. And that's what makes this case different from many of the other ones where there were offers of additional depositions, where there were offers of a continuance. In this case, Mr. Kolke didn't do any of that. He didn't offer anything or move for anything that would have enabled us to alleviate that prejudice. And instead, when the trial court made one offer, well, would you agree to pay fees to alleviate the prejudice, they refused. And this is a case, as in all cases, where relief should have been sought before trial. And waiting until trial to seek to withdraw these deemed admissions and file responses caused some other problems. Homeowners Choice would not have been able to move for better answers, would not have been able to use those in depositions, wouldn't have been able to take further discovery had those been withdrawn in the trial posture. And the appellant in this case didn't do anything to try to take the case out of that trial posture. Didn't move for a mistrial. Didn't ask for a continuance. And so what happened was that leaves the trial court with a few options. All the trial court could do was either let the case go to trial despite prejudice or grant the directed verdict. And the trial court granted the directed verdict. I would add one point that I don't see excusable neglect anywhere in the rule as an independent basis to permit withdrawal of the admissions. The rule says what it says, and excusable neglect is not a separate independent ground. Then on our third point, aside from the issue of prejudice, the rule required a showing that presentation of the merits of the action will be subserved by withdrawal of the admissions. And this is typically addressed, as we mentioned, by whether there's evidence in the record that contradicts the admissions. And here the trial court went through a very detailed list of everything that it reviewed in the record. And Mr. Kolke did not point to anything specific, only the complaint and that he had deposition testimony, although he didn't point to any specific testimony. and to a single interrogatory answer, which said that the appellant seeks damages under various coverages which have not been paid. In the trial court and in the initial brief, he didn't point to any other specific areas of the record or explain how they contradicted these admissions. And we would submit, as I mentioned earlier, that arguing this for the first time in the reply brief, it is too late. So I would submit that this appeal here presents a narrow and discrete issue. Did the trial court use its discretion? Was the trial court required to allow the appellant to withdraw the admissions when he did not seek relief until trial, until after the jury had been sworn? When Homeowners Choice made an unrefuted showing an argument of prejudice, and when the appellant did not point to specific places in the record that contradicted each admission. In the cases that have been cited in this appeal, the appellant has relied on a series of summary judgment cases in a pre-trial posture, which don't speak to the issue in this case where we were in a trial posture. The only trial posture cases that were cited involved bench trials. And in many of those cases, they asked for relief multiple times before or during trial. Or in those cases, prejudice was not shown. Or in those cases, the party offered to allow additional depositions, offered a continuance to alleviate the prejudice. That's not the facts of this case. In this case, there was a jury trial, the jury was sworn, and then the appellant asks for relief for the very first time. Did not seek a mistrial, did not seek a continuance, did not offer anything to overcome prejudice. Rule 1.370 does not require the trial court to grant relief every time a party asks for it. The rule deems requests admitted when a party does not respond, and the rule contemplates that a party can and will use those deemed admissions in trial. If the trial court, in this case, was required to allow withdrawal of admissions on this record and during that trial posture, it would vitiate the rule. The rule would have no meaning at all, and parties could never rely on admissions when they prepare a case for trial. The trial court may have misstated the burden, but it reached the right result that was well supported by the record. The trial court did not abuse its discretion, and we would ask that the decision be affirmed.
Chief Judge, may it please the court, two brief points of rebuttal. The first is, I think, a question of framing and how this court looks at the facts of this case. When the requests for admissions were served, the question is, were they truly served to frame the issues in the case as trial counsel argued? Or was it a litigation tactic that was setting up a procedure to see what would happen later down the road? And there's a call up with the court where trial counsel for HCI admits that it was a gamble, that they could have gone all the way down on this request for admission that was basically, did we breach the policy? Do you believe what you said in the complaint? And they took the gamble as a litigation tactic that it was going to pay off down the road.
Counsel, that's a gamble within the confines of the reason for the rule on requests for admissions, right? I mean, the rule's very clear. 30 days to respond, correct?
Yes, Your Honor.
It's very clear. So, I mean, obviously the gamble is, the first gamble is that you're not going to violate or blow the deadline.
Yes, Your Honor.
So, and then the second gamble is that once you get and you're in front of the court and requesting relief, the court isn't going to grant the relief from the failure to respond to the request for admissions, correct?
Sure. Yes, Your Honor.
Okay. But you took a gamble on behalf of your client, or trial counsel did, when the court, even at that point, was trying to explore additional relief, and which would have included a request to continue the case, and your client or counsel for your client refused that proposed relief, correct?
I don't recall in the record seeing a continuance offer. The only relief that was offered by the trial court was pay all of the attorney's fees and costs incurred today, which I think at the time didn't seem to match curing the prejudice. I think that was the issue. And Your Honor is exactly correct.
But in light of the fact that you had a sworn jury in the box and you were getting ready to start the trial, that was at least proposed by the trial judge as a way to lessen the impact and or potentially explore further relief, which would include potentially mistrying the case, retrying the case, taking time out for depositions to engage in full discovery. All of those things were basically short-circuited by trial counsel's decision to deny or refuse that proposed option from the trial judge, correct? So that was a gamble.
Potentially, Your Honor, but I don't see, when you look at the call, we both, that point and leading up to it, there was no suggestion by the trial court of any inclination whatsoever that it would be a payment of fees and costs plus continue the trial, right? Or payment of fees and costs plus we're going to declare mistrial and you're going to be responsible for the mistrial costs. It was a out of the blue, well, do you want to pay all the attorney's fees and costs incurred today? No, we don't. And then they continue to move on to the analysis.
What remedies did trial counsel offer on behalf of Mr. Butler?
The only remedy was of asking for the relief of remission. There wasn't neither side asked for continuance, neither side asked for mistrial, neither side asked for more time to do depositions, neither side asked for anything other than judgment and relief. That was how the parties had framed it. But going back to Your Honor's question, I think the point of how this case is framed is that it goes to the issue of prejudice, and that as a litigation tactic, when the counsel waited until the moment the jury was sworn, because it happened that fast. This wasn't in the middle of the trial, record verdict, right? There's even a footnote in the trial court's order that says, this is kind of wonky doing it this way because it's not at the close of evidence. I'm doing it literally minutes after the jury is sworn. Counsel for the defendant stands up and says, I've got a motion for a directed verdict. And the question is, when discovery has been done in the case, when the requests for admissions are not actually framing the issues, but are asking the plaintiff to admit he doesn't have the case, and I see my time is back, can I finish my sentence? When it's not framing the issue, it's not red light, green light, it's not, did you sign this, did you not sign this, when it's admit you brought a baseless complaint, and then having to be faced with the question of do we enter judgment as a sanction against the plaintiff or let the case go forward to explore other options for relief on the merits, the trial court erred in granting judgment on it. Thank you.
We're going to be in informal recess. The council can stick around for a few minutes while you're putting your papers away. Mr. Bailey, Mr. Hall, thank you. We have some law students from Stetson, not law students, pre-law students. They'll be law students.